And I'm going to tell the panel that at the end, that your evidence must be rejected as incredible because it is irresponsible to make such a claim without having read the docket.
It's not irresponsible at all, and I'll explain why.
For you to tell the panel that there is no case against Major General Boysen, also of racketeering, without ever having studied the docket against him, is a grossly irresponsible thing. Well, I'm told it's also uploaded electronically. So for those where they don't have individual hard copies, it's accessible. If the panel has file 1 and file 2 of the cross-examination bundle.
I have I beg your pardon. I have file 1 and file 2. My sister has file 2, file 2.
All right. No surprises there. Thank you, Chair. I may commence then.
Thank you.
Thank you. Advocate Batoy, I understand that you started as the NDPP on the 1st of February 2019. Is that correct?
That is so.
And in your evidence, you stated that one of the cases that you inherited was an application for the judicial review brought by Major General Boysen against the racketeering certificate, which had been issued by Advocate Sean Abrahams. Is that correct?
That is correct.
Yes. Then you also stated that you instructed a panel led by Advocate Rodney de Kock to review the evidence and to give you advice on the way forward. Is that correct?
That is so.
Yes. Then Advocate de Kock gave you the advice on the 27th of June 2019. Is that correct?
I don't have the report in front of me, but I have no doubt that that's correct.
Yes. After you received the report, you withdrew the opposition to the case.
That is correct.
Yes. Now, there's something that doesn't make sense with this narrative. I presume that the NPA had senior counsel on brief to defend the application. Is that correct?
I beg your pardon, Counsel. You take it slowly.
Thank you.
Take it slowly. The withdrawal of the matter following Advocate de Kock's report pertains to the Katomena matter.
Yes. Yes. Thank you. Now, Advocate Bahato, there's something that I need to get clarification because it doesn't appear to make sense to me. I assume that the NPA had briefed senior counsel to defend the application by Major General Boysen. Is that not correct?
My recollection is that is the case.
Yes. Now, did you take advice from the senior counsel on the prospects of success in defending the application?
I don't think so.
Well,
I'm trying to think back. I'm trying to even think who the counsel was.
well, I can tell you who the counsel was. It was Advocate Hilton Epstein.
That's quite possible because he was dealing with a number of matters at the time.
Well, I've got this information from Advocate Sean Abrahams. He had briefed Advocate Epstein. Now, you haven't answered my question. Did you take advice from Advocate Epstein or not?
No,
All right.
I don't think so.
All right. And did he give you any written advice?
I can't recall.
Advocate Batoy, it can be no, and you can't recall at the same time.
Well, I can't recall whether he did. And it's difficult trying to cast your memory back a number of years. I know he was dealing with a number of matters, and this is, as you say, one of them. I honestly can't recall whether he did give any advice.
The problem I have is that you've disclosed many legal opinions, and you have not mentioned Advocate Hilton Epstein at all in your evidence in chief or in your statement. So I'm wondering, why have you suppressed that information?
I haven't suppressed anything. I honestly can't remember whether he gave us any opinion on this.
But nevertheless, it seems to me that a responsible NDPP would have asked the senior counsel on brief for an advice on the prospects of defending the application.
In my view, I had the opinion of a very senior, experienced team from the NPA, and I accepted their advice.
I'm talking about before you obtained the opinion of Advocate de Kock. Advocate de Kock gave you an opinion only on the 27th of June, but you had been seized with the matter as soon as February 2019. I'm asking you, you've said initially you did not obtain advice. Later you said you don't recall if you obtained advice, but I'm asking you, it seems the most prudent thing would have been to ask the advocate you have briefed for advice. Why did you not do that?
In my view, the most experienced persons to give me advice on this racketeering issue would be persons in the NPA who are experienced with racketeering. And that is why I decided the most appropriate and reasonable way would be to get not just one person, but a panel of 4 people, very experienced in these issues, to give me a view on this.
Yes. And I just want to make sure that I've given you a fair chance on the question whether you did or did not obtain advice from Mr. Hilton Epstein, because I'm going to ask the panel to give me a chance to consult with him and to ask him whether or not he gave you advice. And you've given so far 2 inconsistent answers. One, I don't remember. Other, no, he did not give me advice. Do you want to consider your position?
No, I really am trying to think about what happened at the time. My initial response was, in fact, I really don't remember, but having thought more, I'm inclined to think that I did not get it from him. But of course, you are most welcome to speak to him, and we will also check our files to see if there's anything to that effect. But we're certainly not suppressing anything.
Now, my instructions are that, in fact, there was a meeting with Mr. Epstein on the 6th of March, 2019, called by you at your office, which included the state attorney, Mr. Sebele Metza. Do you remember that?
I did have meetings with Mr. Epstein.
You did have meetings with
him. It may have, in fact, been more than one, because he had been dealing with a number of matters in the NPA. And so I just wanted an update on what was going on.
Yes, I'm asking you about one meeting, which is the 6th of March, 2019. Not asking you about other meetings.
All I'm saying is that I did meet with him, and that is possibly also a date on which I met with him.
Now, that meeting, I understand, was also attended by Counsel for Major General Boysen, Advocate Anton Katz. Do you have any comment on that?
Unless my memory is failing me, I can't recall having a meeting with Katz and Epstein. But I'm not saying that it didn't happen, but I really, at this point, I can't remember that.
Well, it would have been a big story on your diary that you have called the advocate who represents the person who is suing the NPA into the same meeting with the advocate who's defending the NPA. I'm not understanding why you cannot remember such a big event.
Well, it may be a big event in your calendar, Advocate, but for me, I meet with lots of counsel, and I cannot recall whether they were both in the same meeting.
So your answer is, I don't remember.
That is correct. I do not remember.
Just like you don't remember if you got an opinion from him or not.
That is correct.
Yes. Now, I am also told that it was at that meeting that you instructed the state attorney to withdraw the opposition to the Major General Boysen application.
What date was that?
6th of March, 2019. I presume you also can't remember.
I can't.
Yes.
I beg your pardon. The answer, if I understand it, is that you don't remember the meeting
No, whether
where Advocate Katz was present,
Mhm.
or what is it that you don't remember?
The last question was whether I gave an instruction to withdraw the opposition to the review application on that date. And I cannot recall that.
Yes. Can I ask you then, Advocate Batoy, because legal opinions are privileged information, can I ask Advocate Epstein to give me from his records the advice, if any, that he gave you?
This is an inquiry seeking to establish the facts. I have no issue with that.
Yes, oh, thank you. Because it seems to me, if your evidence is that you only took the decision to withdraw the opposition on the 27th of June, after the 27th of June, that would be fundamentally inconsistent with the facts as they happened, which, as I understand, already that decision was taken by the 6th of March, 2019. Would you accept that?
That would be inconsistent, yes.
Yes, all right. We will come back to that topic after I have spoken to Advocate Epstein. Can I ask you another topic? You have repeatedly mentioned state capture in this inquiry. Do you remember that?
I do.
Yes. Now, the definition of state capture as adopted by the commission under Justice Sondo is a misuse of the state and its organs for private gain or for unlawful aims. Do you accept that definition?
Yes.
Do you have any personal knowledge that Advocate Chauke was involved in state capture?
I don't have any personal knowledge.
Yes, all right. So then it was grossly irresponsible of you to mention state capture in the context of Advocate Chauke when you have no personal knowledge of his involvement in state capture.
Should I comment on that?
If you want to, I'm putting it to you that I will argue that you were attempting to poison the atmosphere when you had no evidence, but you mentioned state capture together with Mr. Chauke.
The reason why I did is that I was asked about why I took certain actions when I did. And I explained that because that was in fact the NPA and capture of the criminal justice system was something that the Zondo Commission was inquiring into. And I couldn't turn a blind eye to the fact that that was what was being inquired into, and that as a responsible national director, in my view, I needed to consider all options. And the only reason why I mentioned it is because I was asked about the context and why I took certain actions. And that was what was also something that was on my mind at the time. So I considered all of this, and therefore I took certain actions.
Advocate Batoy, we are in an inquiry against Advocate Chauke. We are not in a state capture inquiry. My question was simple. You've given me an answer. You have no evidence that Advocate Chauke was involved in state capture. Yet you have repeatedly mentioned state capture in the context of this inquiry into Advocate Chauke. That is what I am saying to you, is intentionally designed to poison the atmosphere of this inquiry, to create the impression that Mr. Chauke is involved in state capture, when you know full well that you have no such evidence.
I was asked what were the reasons for me doing certain things at the time. And I explained that that was the context within which I took those decisions.
Yes. Anything else to add?
No.
Now, can I then move on to another topic, just to understand these charges? My understanding of the way in which these terms of reference emanated is that you drafted them and the president endorsed your draft. Is that correct?
Well, actually, what happened is we went and checked this after. We did submit a draft to the president, but what the president adopted subsequently is quite different from the draft, and we didn't input into any draft that the president had. So there is a difference between the two.
All right. Well, I have not seen the draft you gave the president. And maybe you should send us that draft, because I understood all along is that the president endorsed the draft that you gave to him.
No, that's not the case. We can let you have the draft.
Yes. Now, can I then go to making sure that I
I
understand?
beg your pardon. Advocate Batoy, what is the answer? You're saying Advocate Ngcukaitobi can have the draft.
That is correct.
Do you have it?
We do have it.
Thank you, Madam Chair.
Has it been made available to the evidence leading team, that draft?
I'm not sure if it has.
May we ascertain whether the draft document that was sent to the president as regards the terms of reference has been made available to the team? May
Sure.
I just verify with Advocate Mutlamanyane? Has it been made available to you?
Madam Chair, I'm not aware of any draft. All what I'm aware of are the terms of reference that have been gazetted.
Might we find out from your team, Advocate Halley and Junior and the lady next to you, if you probably have the document in your possession? It may also be relevant, I'm not sure at this stage, because you have raised, Advocate Batoy, a question of the correctness of not necessarily that way, because you seek to amend the terms of reference, correct?
That is correct, Chairperson.
That document may be relevant in determining what you conveyed to the state president.
Sure.
May it be made available if you have it? Madam,
We got it. Yeah.
Advocate Haley and Junior.
Madam Chair, we no doubt will make it available, but my instructions are, and I've got to verify this, but my instructions are that it already is there, but I stand corrected. I would have to verify it myself.
Do you have it though? Do you have the document?
Not as we
Because-
speak right
Not
now.
at this stage.
Yes.
Are you making an undertaking, Advocate Batoy, that your office will make available the initial letter or document, whatever it is, or a memo to the state president?
Yes, we will.
When will we have the document?
Today, as soon as we are adjourned.
Yes, thank you. Will it help, Advocate Ngcukaitobi?
Yes, Madam Chair, it will help. I still have one more question on the issue of this draft. Advocate Batoya, I want to confirm whether it is your testimony that the draft you gave to the president is different to the terms that the president finally signed.
That is correct.
Yes. And you cannot at this stage tell us what the differences are.
I can't.
Yes. All right. Can we then go to the terms of reference that the president endorsed? Because I am not understanding them. They have been referred to in several parts of the case. Hopefully the panel can access the terms of reference easily.
I'm trying to find my copy, Chairperson.
Do you have the copy,
I don't have it yet.
Advocate Mutlamunyane? Do you probably have a copy that we can give to Advocate Batoi? A copy is now made available.
I do
to
have a
us.
copy.
Thank you.
Thank you. Can you go to item 3.1.1? It reads, the institution of the racketeering charges in terms of Section 2, subsection 4 of the Prevention of Organized Crime Act 1998 against Major General Boysen and members of the Ngcukaitobi unit, and the defense of those actions in subsequent review proceedings brought by Major General Boysen to have the racketeering certificates set aside in that. Now, there are a couple of points that arise from that. The first one, is that charge limited to racketeering or does it include the predicate offenses?
Racketeering, by its very nature, includes predicate offenses.
Yes, but you know what I'm asking you. I'm asking if the murder charge standing alone is included or excluded. And if I can give you an example to make it easy. Major General Boysen is charged with 7 counts, 2 of racketeering, 2 of murder, 1 of defeating the ends of justice, and 2 of violating the provisions of the Firearms Control Act. My question is a simple one. Does that charge exclude the 2 murder charges, the 1 charge of defeating the ends of justice, and the 2 charges of violating the Firearms Control Act?
As I said, racketeering by its very nature includes the predicate offenses. So it must include the predicate offenses as well.
Advocate Batoi, please answer my question. I am not asking you about racketeering offenses and its elements. I promise you I can read for myself. I'm asking you whether or not the independent charges of murder, the independent charges of defeating the ends of justice, and the independent charges of breaching the Firearms Control Act are included or excluded.
My answer to that is that it includes racketeering charges.
I know it includes racketeering charges because it says racketeering. I'm asking you if it excludes the charge of murder against Mr. Boysen.
It does not exclude it in the context of racketeering.
Advocate Batoi, I think we are going to be here for a long, long time if you don't answer the questions directly. We know racketeering, in order to establish, requires predicate offenses. That's not what I'm asking you. But I'm asking you is that Major General Boysen was charged independently of murder. Is it suggested in this charge that he should also not have been charged of murder independently of racketeering?
That's not what I'm saying. What I'm saying is that I can't, that's my answer, is that the predicate offenses are included in the racketeering charge. And so my understanding is that he would have been charged for those predicate offenses in the context of racketeering.
I honestly do not understand that. And let me give you a final chance. If you withdrew racketeering, Major General Boysen will still face a murder charge.
That's a different question, and I'll answer that now.
Yes,
So
now-
when I did withdraw the racketeering,
No, I'm not asking you to answer anything. I'm telling you the question that I'm going to ask you. Is 3.1.1 intended to suggest that Major General Boysen should not have faced the murder charge?
not at all.
So you accept that he should have continued to face the murder charge or not?
Can I answer that question?
Yes.
After I decided to withdraw the racketeering charges, I sent all of the dockets back to the DPP KZN and asked her to consider each one of them and whether anyone should be charged with the predicate offences outside of racketeering.
No, I still don't understand that. I'm asking you about the charge against Advocate Chauke. Whether or not you accept that there was sufficient evidence for Major General Boyson to be charged with the crime of murder or not? Or do you say there was also no sufficient evidence of the crime of murder?
On the basis of the decisions of the DPP KZN, after I sent the dockets there, she found that there was no evidence to justify murder charges against any one of the accused, except in the one docket. And that did not include Major General Boyson.
Yes, those are later decisions. I'm asking you about the decisions taken by Advocate Chauke. Is it the case of the NPA that Advocate Chauke erred in charging Major General Boyson with murder?
My understanding is that Major General Boyson was charged with racketeering and that those were the predicate offences.
Yes.
And that is where we say Advocate Chauke erred in supporting racketeering charges.
Yes.
I beg your pardon, Advocate Ngcukaitobi. Is this question premised on the assumption that Advocate Chauke made a prosecutorial decision to charge?
Yes, I'm working now on the best case for the NPA.
That's why I'm asking the
Yes,
question,
no,
because all along, when we read the opening address, it seems to me that there was an issue regarding whether he made a prosecutorial decision
Yes.
in relation to the Katomena matter. My understanding of the evidence favorable to you was that Advocate Chauke was appointed merely as a coordinator in relation to the KZN Katomena matters.
Yes.
That's why I'm asking the question as to whether you premise this question on the assumption, at least for now,
Yes.
that he did
Yes.
make this particular
Yes.
prosecutorial decision
Yes.
as regards the charge of murder against Major General Boyson.
Indeed. I'm working now, Madam Chair, on the best case for the NPA, that Mr. Chauke has taken all of the decisions they claim. I'm trying to understand the substance of the complaint, but I will still deal with whether he did make those decisions or not. So I'm still trying to analyze the charge. Let's come back then, Advocate Betoy, to understand what 3.1.1 is about. You have said that your understanding is that murder featured only because it was a predicate offense, not because it was an independent offense. Is that correct?
It was a predicate offence to racketeering, that's correct.
Yes. And therefore, it is irrelevant to Section 2, subsection 4 as an independent offense. It is only relevant as a predicate offense.
That is correct.
Yes. All right. Now, the reason I'm asking you this is because even on your own version, you've accepted that at least in relation to one of the charges, there was sufficient evidence to prosecute. Is that correct?
No, I'm not understanding you.
Well, you've told us that you gave all of the dockets to the DPP of KZN. She enrolled one case against Mr. Padiache on a count of murder. So she must have considered that there was sufficient evidence to charge Mr. Padiache with murder.
Yes, I didn't realize you were referring to that docket. That's correct.
Yes. So that's why I come back to say, in at least one of the cases, there was sufficient evidence to proceed with a murder charge.
That's correct.
Yes. Now, that distinction is not made clear at all in 3.1.1. If you read 3.1.1, it suggests that in none of those cases, there should have been a charge.
against Major General Boyson. That's what that suggests.
No, that is false. It says Major General Boyson and members of the Cato Manor unit.
Let me read this carefully.
Mr. Padayache was a member of the Cato Manor unit.
The point I made earlier is that this related to racketeering charges. And therefore, it's clear here that this section is relating to racketeering charges and murder as a predicate offense and not as separate independent charges. And so it's correct in that regard that it is racketeering. It doesn't refer to murder at all.
Yes, I thought we had moved from that question and we were debating the independent charges. And I asked you a question, whether you would accept that in at least one of the dockets, the case against Mr. Padayache, there was sufficient evidence to charge. And I understood your answer to be yes.
That was my answer.
Yes. And when I proceeded with that, you said, well, exclude Major General Boyson. And then I pointed to you that actually exclude all members of the Cato Manor unit.
The point I make is that whether it's Major General Boyson or all members, this particular paragraph refers to racketeering charges and not independent murder charges.
Yes. Now, could I then ask you to turn over the page? 3.1.1.1 refers to supporting a decision to prosecute the accused. Who is the accused?
All the accused in the racketeering charges.
Yes, that's where we come back from, where you say no evidence justifying the decision. And now we understand that you would accept in relation to one, that there was evidence justifying a murder charge against Mr. Padayache.
But not a racketeering charge.
Yes,
against
I understand.
anyone.
You've made that clear. I'm asking you a different question. Was there sufficient evidence, in your opinion, having studied the dockets, if you did, to support a murder charge against Major General Boyson?
There wasn't.
There wasn't. Now, you gave evidence earlier that you did not study the dockets and you relied on a memorandum by Advocate de Kock. Was that evidence accurate?
That's correct. But my answer now also relies on the evidence of a report of the DPP KZN.
Yes. I'm not asking you about the DPP KZN. I'm asking you, at the time you took the decision to institute a disciplinary case against Advocate Chauke, you relied on the report of Advocate de Kock. You never studied the docket. Is that not correct?
That's correct. I didn't, let me just check the time that I decided. No, that's correct. I didn't
Yes.
study the dockets, the 23 dockets.
Yes, I'm asking just the docket around Major General Boyson. 2 murder charges, 1 charge of defeating the ends of justice, 2 charges of violating the Firearms Control Act. Can I tell you, Advocate Chauke read the docket. Did you know that?
I would have expected him to.
Yes. But you have come to say to the panel, there was no case against Major General Boyson without ever having read the docket. Can I suggest that that is an astonishing proposition coming from the head of our prosecution service? And I'm going to tell the panel that at the end, that your evidence must be rejected as incredible because it is irresponsible to make such a claim without having read the docket.
It's not irresponsible at all, and I'll explain why. There's case law that national directors are not expected to read every single bit of evidence and every docket in cases, and that they are, it's perfectly acceptable for a national director to rely on reports, to rely on presentations, to request aspects of evidence, and to take decisions on that basis. So it's certainly not irresponsible. It is what is expected of a responsible national director.
Yes. But can I also suggest something else to you? That Section 2 of the Prevention of Organized Crime Act is within the exclusive power of the NDPP. Do you accept that?
I'm not sure what you mean by exclusive power, but
Well,
certainly
only the NDPP can sign a racketeering certificate under Section 2, subsection 4. I would have thought that to be obvious.
certainly I agree that only the national director can sign that authorization.
And exclusively the NDPP. No one else can sign a racketeering certificate.
That's correct.
Yes. It's in that context that I say, for you to tell the panel that there is no case against Major General Boyson, also of racketeering, without ever having studied the docket against him, is a grossly irresponsible thing.
I repeat what I said.
Of course.
There's case law that states that a national director is not expected to read every docket and to look at every piece of evidence before coming to that conclusion. A national director, it's permissible for a national director to consider evidence that is presented to him or her by a team, presentations, and to ask for specific aspects of evidence if he or she requires it. But it's certainly not expected of a national director to read every single docket in any context. Sometimes a docket can fill a room, and it's certainly not expected that that is what a national director should do.
Well, can I challenge you on that and put two propositions to you? Firstly, the docket against Major General Boyson does not fill a room. It's a small docket. Do you accept that?
I'm not sure that there is a docket against Major General Boyson. I know that there were 23 murder and other related charges, dockets. I'm not sure that there ever was a racketeering docket as such.
Now, you see, the problem is that you answer, but you always overlook what you wrote. Go to 3.1.1.1, where you say, supported a decision to prosecute. I mean, I know you say it's the president who says this, but you never wrote this, or you don't know the difference, so I will accept that until I see what you wrote. Your answer remains qualified.
Mm-hmm.
That there was no evidence justifying the decision, and that he sought to improperly have the acting director of public prosecutions of KwaZulu-Natal sign the case dockets. You are the one who relied on case dockets. Now you are telling the panel there was no docket.
I said there were dockets, lots of dockets, but I'm not aware of a racketeering docket as such.
Advocate Batoy, I think there is a real problem. You have said that 3.1.1 is exclusively about racketeering and does not include the independent offences. And you have also confirmed in 3.1.1.1 that too is exclusively about racketeering. The charge refers to case dockets. What case dockets are those?
Which charge refers to case dockets?
Read 3.1.1.1.
Yes, it does appear there.
It was put there by you.
I'm not sure about that. We'll have to check that.
Yes, but then answer my question, please. The docket that is referenced we have gone through this exercise ourselves. It is only 7 charges against Major General Boyce. It is not the exaggerated docket that fills a room. What do you say to that?
The only point I made about dockets that fill a room is to make the point that it is not expected of a national director to read every bit of evidence when a decision is made. That's the only reason why I mentioned that. But getting back to this issue, there were dockets relating to, there were the 23 case dockets. I'm not aware. Let me read this carefully before I answer this. This is clearly incorrect, because to say that he sought to improperly have the acting director of public prosecutions of KwaZulu-Natal sign the case dockets. It's not our case that Advocate Chauke asked the DPP to sign any case dockets. So this is clearly incorrect. And
So the charge is incorrect.
If I may be allowed to
Yeah,
complete.
all right,
this.
sorry, I thought you had finished. Please
It's
continue.
okay. And or the prosecution memo. He sought to improperly have the acting sign the case dockets and or sign the prosecuting memo. If you read it like that, it's incorrect. That is not what we're saying.
So charge 3.1.1.1 is a wrong charge.
It's incorrect.
Well, incorrect and being wrong are the same thing.
Well, part of it is correct, is that Advocate Chauke supported a decision to prosecute the accused, notwithstanding that there was no decision, no evidence justifying the decision. And then the next part of it is incorrect to the extent that I've indicated.
You see, that's why I need the memorandum you gave the president to see whether the president is at fault for charging Mr. Chauke incorrectly, or whether you are at fault but are now escaping responsibility.
I'm trying to explain as best I can and not to escape responsibility.
Yes, no, I understand that. I'm not criticizing you, I'm criticizing your evidence.
It's fine.
Now,
Before you proceed, I think this will also help us, Advocate Batoi. When you look at the gazetted terms of reference, the date is the 30th of September, 2025.
I don't have that gazetted copy in front of me.
The front page
Oh,
of
there you
the
go.
Gazette,
I have it now. Yes, that's
Regulation
correct.
Gazette number 11889, volume 723, 30 September 2025, number 53444. You
That's
have
correct.
that. When did you see for the first time the gazetted terms of reference?
I'm not sure, Chairperson. I can't recall when I saw it for the first time.
Should I assume that by 1 October 2025, you had already looked at the terms of reference?
No, we can't assume that, Chairperson.
Should I assume that by the 17th of October, when this inquiry started, I beg your pardon, by 17th of November, when this inquiry started, you had already looked at the gazetted terms of reference?
Chairperson, I honestly can't remember when I looked at it and whether I scrutinized it at any great detail or cast a quick look through it. I honestly cannot recall that.
When you took oath, the first day you took oath, had you already looked at the terms of reference?
Chairperson, on the first day of the inquiry,
On the first day you took oath,
I would certainly have had a look at it, but I don't know to what detail.
you may proceed, sir.
Just one thing. Advocate Batui, when the bundles or documentation was prepared for this inquiry, it was prepared with a view to addressing issues raised in the terms of reference. Is that correct?
I'm not aware that it was prepared for that specific purpose.
Did you care to establish as to whether the documentation was prepared for that purpose?
No, I didn't.
Sorry, a follow-up. Advocate Batohi, when you prepared your affidavit together with your legal team, you knew that you were preparing an affidavit to come and testify in relation to the terms of reference in this inquiry.
I knew that I was preparing an affidavit in order to come and testify before this hearing.
Testify in this inquiry in terms of the terms of reference, wherein you referred a matter to the president, who then constituted an inquiry and issued the terms of reference to deal with whatever you referred to the president.
Yes, the terms of reference were for the panel, and of course, evidence was going to be provided to support what's in the terms of reference by various witnesses.
Advocate Batohi, when you prepared your affidavit, you prepared your affidavit to sustain the allegations that you made to the president, which, well, I'm not sure whether rightly or wrongly, convinced the president to constitute a panel. But the president depended on the evidence or on the information that was supplied by you, which you intended to support by way of an affidavit that served before this panel. Is that correct?
I didn't prepare the affidavit with an intention to support the terms of reference. I prepared an affidavit on the basis of what I knew and what I did in this matter. It's not like I prepared the affidavit and then checked whether it's aligned with the terms of reference. That's not what I did.
And what you knew is what you submitted to the president for the president to take a decision to set up an inquiry.
That's correct.
Thank you.
Thank you, Madam Chair. Advocate Batohi, I'm not yet done with this inquiry about case dockets.
Mhm.
You have now testified that the reference to case dockets and trying to get someone else improperly to sign is incorrect. Okay, I'm not going to quibble with that.
Mhm.
But do you accept that the case against Major General Boysen, whether contained in a docket or elsewhere, is a fairly narrow case? It is not the example that you posed of a docket filling up a room.
It's certainly not a docket that fills up the room. That's correct.
Yes. Now, it also continues to say, and or prosecution memorandum.
Mhm.
That's one of the things I don't understand. You never gave evidence in this inquiry that Advocate Chauke sought to have Mr. Molotra sign a prosecution memorandum. Is that also incorrect?
I mentioned earlier that is incorrect.
Yes. So both that case docket reference and the prosecution memorandum are wrong.
It is not our case that Advocate Chauke sought either of those to be signed by Advocate Molotra.
Yes. Now, then it continues to talk about evidence implicating the accused. Who is that accused?
I would imagine it's all the accused.
All of those accused with what? Because there are people like Mr. Mostert, 11 counts of murder. Does it include them or not?
For racketeering charges.
So all of the accused on racketeering.
That's correct.
Yes. Now, the way then it would read is that the case docket would be a case docket for racketeering. The prosecution memorandum would be a prosecution memorandum for racketeering. But because the charge is wrong, we can strike that out. We can put a red pen across that.
Can you repeat that?
I'm saying the way it would read before your evidence today, the way it would read would be it's the case docket for racketeering. And then it's the prosecution memorandum for racketeering. But because you have now considered that that is a wrong charge,
I have a case docket for racketeering. I'm aware of a lot of other dockets, the 23 murder dockets and related charges. I don't even know if there was a case docket for racketeering. So I don't understand your question.
well, my question is exactly linked to what you have just said, that you've charged someone for trying to get a signature on a case docket that you say doesn't exist. You've also charged someone for trying to get a prosecution memorandum to be signed, which you admit was never done.
I have not charged anyone for that.
All right.
I did indicate that that is definitely not the case, and that is definitely an error on that, because there's no evidence at all that Advocate Chauke was required to do any of these, either sign a case docket or sign a prosecution memo.
Yes.
The evidence is that he sought Advocate Molotra to sign the indictments.
Indeed, there is not a single charge here that refers to an attempt to sign an indictment. If
That's
you can
correct.
see it, show me.
That's correct, there isn't,
Yes.
and it's not meant to be, because
Yes.
there's no evidence to that effect.
No, I thought you said the case against Advocate Chauke is that he sought to have Advocate Mlotra sign an indictment.
That's correct.
I am saying to you, there is not a single charge here that refers to Advocate Chauke attempting to get Advocate Mlotra to sign an indictment.
That's correct. I'm
Yes.
not aware of the other, if it's anywhere else on this, but
But
certainly
you
not
can go
in
through
this.
them now, there is enough time. And then show me where it is alleged that Advocate Chauke sought to have Advocate Mlotra sign an indictment.
Well, it may or may not be there, but that is our case.
Well, Advocate Batoi, please.
Just before you proceed, just one thing. Advocate Batoi, did you familiarize yourself with the terms of reference?
No, I didn't.
And you are the complainant in this matter?
That's correct.
Thank you.
Well, you can call me the complainant. It's the president that decided. So I'm not sure that I'm the complainant, but I certainly made a referral to the president.
Which question are you answering now?
Whether well, it wasn't a question, it was a comment that I am the complainant in this matter. And I'm seeking to clarify that I don't see myself as a complainant. It's
Thank
the
you.
president who decided. I made a referral to the president.
Thank you.
All right. I'm going to come back to this question by Madam Panel Member Ramakhaga, but I still want an answer to my question, which is, show me where it is alleged that Advocate Chauke sought to have Advocate Mulojwa sign an indictment.
I accept from you that it isn't, otherwise it's going to take me a while to read this entire terms of reference.
No, it won't take you a while. There are only 5 paragraphs. So you can do that now and tell us which paragraph refers to Advocate Chauke trying to get Advocate Mulojwa sign an indictment.
May I, Advocate Ngcukaitobi? It's 10:15. And perhaps in fairness to you, Madam, as we take a 15 minutes tea break, you will go through the terms of reference to enable you to answer the question that Advocate Ngcukaitobi has just asked you in relation to whether there is any referral in the terms of reference, if I capture his question correctly, that appears in the terms of reference in the entirety. And when we reconvene, you will then answer the question. Advocate Ngcukaitobi?
Perhaps, Madam Chair, we can also get the draft, because I want to put her draft and the president's decision side by side. If we can get that during this 15 minutes, that would be appreciated.
Yes, I was going to deal with that. You had just mentioned that the first letter to the president, the referral letter, if I may call it that,